appeal in the matter of Mercer and Alternative Future Group Limited and others.
Yes, Mr. Stillett.
May it please your lordships, I appear with Ms. Hannah Slarks on behalf of the Secretary of State, and my learned friends Mr. Michael Ford, QC, and Mr. Stuart Brittenton appear for the respondent, Ms. Mercer. AFG, the respondent to the Employment Tribunal proceedings, does not appear and is not represented. As your lordships will have seen, the Secretary of State appeals against the decision of the EAT that in the light of Article 11 of the Convention, Section 146 of the 92 Act should be read as conferring a right on the part of workers not to be subjected to any detriment for participating in industrial action. If I may begin with some housekeeping matters, the court should have an agreed appeal bundle and a one-page supplemental bundle, if that counts technically as a bundle, which may simply be at the back of the court's appeal bundle.
Yeah.
I'm grateful. There is an agreed bundle of authorities, and within the appeal bundle are the parties' skeleton arguments and the supplemental skeletons that they've both put in.
Yes.
There's one additional matter to hand up, for which I'm very grateful to my learned friends. There's a part of the Employment Protection Act 1975 which we omitted to include within the bundle for the complete statutory history. May I hand up copies of that to the court? And it can be substituted for the extracts at 1493 of the authorities bundle. So at page 1493 of the authorities bundle is an extract from Schedule 16 to the 1975 Act. That up to page 1496 can be removed. And
Just could you? I'm just catching up.
no, I do apologise for running ahead, my lord. So it's page 1493.
Yes.
1493 to 1496.
You would like us to take out.
I'd be grateful if you would remove and substitute the extract which I've handed up to the court.
Thank you.
Just one.
Now, just I'm so sorry. Just checking. Now, do we have I think we've got 2-page 1497.
Yes, you probably will.
I don't. Any trouble?
I think we'll manage. I hope we'll manage. Thank you, my lord. Next question of timing. I've spoken to my learned friend, Mr. Ford. The proposal is that I will make my submissions this morning. My learned friend will make his submissions this afternoon, leaving 15 or 20 minutes for a reply. That's on the assumption that the court's able to sit to around 4:15, if that's agreeable to your
Yes,
lordship.
I don't think there's no difficulty sitting. At least I've not heard of any difficulty. And if needs must, I'm sure we could go a few minutes longer, but it's not to encourage prolixity.
Well, we'll certainly do our best, my lord, I assure you. So, with those preliminaries in mind, the provision which we're concerned with here, Section 146 of the 92 Act, has been in existence, we submit, in one form or another for 50 years. But this is the first time it's been held to confer a right not to impose a detriment for industrial action. And we will submit that the EAT, in making that finding, erred in two respects. The first ground of appeal is, we submit, that in holding Article 11 to require, pursuant to the UK's positive obligations, that the UK should prohibit all detrimental action against those participating in industrial action the EAT erred. We will submit, on a proper analysis of the Strasbourg case law, that it does not go that far, and that the legislation, as hitherto understood, strikes a permissible balance between the rights of employees and employers within the UK's, we submit, wide margin of appreciation in this context. Secondly, if your lordships are against me on that, we submit that the EAT in any event used Section 3 of the Human Rights Act impermissibly, not just because we submit that its interpretation goes against the grain of the 92 Act, but more fundamentally because we submit that in effect the EAT has engaged in impermissible judicial legislation in crafting what we say is a new right within domestic law. The difficulty being that there are many forms the formulation could take, and there is no obvious or even minimal formulation which provides additional protection in a neutral way. Every way the right is formulated strikes a different balance between the rights of employers and employees, and this is not a case where Section 3 can simply remedy an obvious lacuna in the legislation. So we submit that is an error of law. And on that second point, we do make the submission up front that it is telling that we already have, in a sense, three candidates for how the formulation should be made. One of Mr. Justice Choudhury in the EAT, the alternative, which we'll go to in due course, put forward by the respondent, Ms. Mercer, and a somewhat different approach taken by Mr. Justice Auerbach in the Ryanair case, which also traversed some of this ground. So that's all I wish to say by way of introductory remarks. I propose to make my submissions under the following 5 headings, if I may. Very briefly, I wish to deal with the background and procedural history of the case. Secondly, I will take the court through the relevant legislative history and the current statutory provisions. Thirdly, I will go to the jurisprudence on Article 11, and that will be the most substantive part of my submissions. Fourthly, I will seek to articulate ground 1 of the appeal, that the legislation is compliant with Article 11, and finally ground 2, that Section 3 does not provide an appropriate remedy in this case. So with that introduction, may I just briefly, very briefly, take the court to the background in this case, because we don't need to go into that in any detail. The ET's decision, we should just look at very quickly. It's at page 132 in the appeal bundle. And one sees at paragraph 7 that in early 2019 there was a trade dispute regarding payment for sleep-in shifts, the claimant employed in the care charity. Having gone through balloting and notification requirements, the union called a series of strikes which ran intermittently. There was no attempt by the respondent to seek an injunction preventing the industrial action taking place. 8, the claimant was involved in planning and organising the strikes. In that capacity, she was interviewed by an online publication, and some press material appeared in the Liverpool Echo. She also intended to participate in the strikes herself, and then at 9, on the 26th of March, the claimant was suspended. The respondent told her it was because of allegations she'd abandoned her shift. And just for completeness, that is the single page of the, or the 2 pages of the supplemental bundle, is the suspension letter of the 27th of March, where the employer says, I am writing to confirm the details of your suspension from duty on full pay with effect from 26th of March 2019 due to the following allegations being made against you: bringing the reputation of the organisation into disrepute, breach of social media policy and abandonment of shift. Yes. And it says at the next page, don't contact any members of AFT or enter the premises. Stress the investigation will be conducted in a fair and consistent manner and does not itself form a disciplinary sanction. So,
can I just put down a little marker that I'd personally be grateful for some absolute clarity on and agreed clarity between you and Mr. Ford, if you could, to identify precisely what the assumed facts are. This case isn't concerned with a sort of general, wide-ranging debate about Article 11. It's proceeding on assumed facts. And the curiosity, as it seems to me at least, is that some of the facts that are recited in the Employment Tribunal decision and the EAT decision are not part of the assumed facts. And there's a sort of continuum of factual allegations. And I've not found it very easy to distill to a sentence precisely what facts we are being asked to assume, and those, of course, are critical to deciding any issue under Article 11.
well, my lord, I think the answer to that is perhaps not the answer that your lordship was looking for, because what one sees in the judgment is that, going back to the EAT decision, page 133, just to complete its account of the facts, the suspension was lifted on the 11th of April 2019, but the disciplinary matter proceeded. 26th of April, the claimant was given a first written warning for leaving her shift. The sanction was overturned on appeal. A grievance which she filed in June 2019 was rejected, and an appeal against that decision was also unsuccessful. So that's all we have in the tribunal judgment by way of background. But
What can I have?
well, give way to my.
I think it's at 5, perhaps, is the key, my lord.
Of the
Paragraph of the tribunal. It was agreed for the purposes of the judgment I should assume that the facts asserted by the claimant in the claim form would be proven at trial.
Yes, but if one looks at the claim form, there are all sorts of things. And you've distilled it in your skeleton argument, I think, Mr. Ford. I can just see to this proposition. The issue on this appeal is whether a worker who was suspended and subject to disciplinary action for the purpose of preventing or deterring her participation in union-organised industrial action.
Yes.
So that's the fact.
Yes, and that comes from, well, do you want me to show you in the claim form?
As long as I'm satisfied that it is an agreed basis upon which we are proceeding.
I'm happy with that.
So if we take paragraph 3 of Mr. Ford's replacement skeleton argument.
I'm happy with that.
Good, thank you.
So you don't want me to show you the paragraphs?
No, if it's an agreed assumed fact, I don't think we need to go further. Thank you, Mr. Ford.
I'm not sure if necessary if I leave anything out, my learned friend can return to it. But I say that with the following caveat, my lord, which is that the way things then proceeded was that at paragraph 17 of the tribunal judgment, it was initially ordered that effectively the matter should be treated as a strikeout.
Yes.
That's at page 133.
That's not how it dealt with it.
I know. You don't have to interrupt me. I know that. I'm taking him through it. But one sees then at paragraph 22, my lord, that after discussion, both sides, this is page 134, after discussion, both sides indicated that despite those reservations, they wished a hearing to proceed. There were concerns about that basis. It was agreed that I should treat this preliminary hearing as though it had been convened to determine the preliminary issue under Rule 53(1)(b). The issue was whether, in the light of Articles 10 and 11 of the European Convention on Human Rights, the activities protected by Section 146 extend to participation in unlawful industrial action as a member of an independent trade union. And so the matter was heard not by reference to particular facts, but that general point of law. And my Lord, in my submission, one can't shrink from that in this case for this reason, that the way the EAT approached it and where we ended up in this was that the EAT effectively drafted an additional subsection of section 146, rightly or wrongly, your Lordships will take a view on that. The effect of that obviously would be wide-ranging and of general application up and down the country in how 146 is interpreted in the future. And it's one of the reasons we submit that it was inappropriate to do so. But as things stand, the EAT's decision does create a wide-ranging new right not to be subjected to a detriment when engaged in industrial action. And so in my submission, one cannot shrink from addressing the general question in this appeal and can't limit it to its facts in that way. So that's the factual background, and the matter was determined by EAT, we see at page 144, sorry, by the ET at 144. It was held at paragraphs 81 and 82 that Drew remained binding domestic authority for the proposition that participation in industrial action at any time is outside the section 146 regime. The ET went on at paragraphs 85 to 86 to find that was not in accordance with Article 11, but then went on at paragraphs 91 to 93 to hold that it was not possible to interpret section 146 in such a way as to remedy that failure to comply with Article 11. The matter then went to the EAT, where it was heard by Mr. Justice Choudhury. His judgment in the core bundle begins at paragraph 78. And the key findings there we see, if we go first to page 93, he found, again, based on Drew and St Edmundsbury, paragraph 28, that under conventional principles of interpretation, section 146 did not extend to industrial action, and at 29 there's no suggestion Drew was wrongly decided, and he noted at 30 that another reason for construing 146 as not extending to industrial action is the requirement that activity in question is at an appropriate time. And he goes on to explain that. And then, so he, on domestic principles, he was against the claimant. He then went on at page 100 to find at paragraph 43 that in his decision, the European Court of Human Rights regards any restriction, however minimal, on the right to participate in trade union sanctioned protest or strike action as amounting to interference with Article 11, and that's where we submit that he went further than was justified by the authorities, respectfully. We then go forward to page 111. We see that he made a finding that there was therefore a violation, at paragraph 68, a violation of Article 11. He then considered the question of reading down under section 3 of the ECHR, and if one turns to page 118, he held that there was nothing to suggest that the grain of the legislation is to exclude protection against detriment for those participating in industrial action. And at 120, we see the drafting. Paragraph 86, limb B says, before me, Mr. Ford suggested that a new subparagraph C could be added to the definition of an appropriate time in section 1462 as follows. C, at a time within working hours when he is taking part in industrial action. So that's the interpretation adopted by Mr. Justice Choudhury.
Mr. Stillitz, can I just ask you about that formulation? It may be something you're coming back to, but as I read it, that's not confined to official action, nor, it seems, is it confined to industrial action, which would be protected by the immunity from tort in section 219.
Yes, my lord, that's correct. Yes. And I will come back to the various formulations at the end of my submission.
Yes.
So that's the history. I now come to the legislation. And it is, this is the second of my submissions, it's common ground that sections 146 and 152 of the 92 Act have their origins in ILO, would appear to have their origins in the Industrial Labour Organisation's Convention 98, which was signed in 1949 and came into force in 1951. If we can quickly look at that, that's in the authorities bundle at page 1659.
Do you have tab numbers?
I do for most of these, and I apologise that I don't for some of them. I will when I come to the authorities, but I can give my lord that. That is tab 63.
Thank you.
And I will endeavour to do so and apologise in advance if I forget.
Don't worry, I appreciate it. It's always difficult.
So tab 63, page 1659 is ILO 59, which you see from the top was came into force in 1951. Article 1, workers shall enjoy adequate protection against acts of anti-union discrimination in respect of their employment. 2, such protection shall apply more particularly in respect of acts calculated to A, make the employment of a worker subject to the condition that he shall not join a union or shall relinquish trade union membership. And then we're concerned with limb B, cause the dismissal of or otherwise prejudice a worker by reason of union membership or because of participation in union activities outside working hours or with the consent of the employer within working hours.
Yes. So this convention is not part of domestic law, but as I think is common ground, it's the springboard for the language that we now see in section 146.
Indeed, my lord. And to be clear, I cite it only to help, I hope, to illustrate to the court the evolution and origin of these provisions. My learned friend makes some points in his supplemental skeleton to say, well, the most recent deliberations of the ILO indicate that this convention may have some relevance to the right to strike. We don't have any difficulty with that. Our point is merely that if one looks at the source of this legislation, it's quite clear from Article 1 to B that that's where it comes from. And moreover, it's quite clear, we submit, that what Article 1 to B is concerned with is not industrial action, but union activities outside working hours or with the consent of the employer, i.e. union meetings, organisation, but the sort of thing that does not disrupt the employer's business. It would then appear that the Donovan report of June 98 was the next sort of point in the historical origin here, because that is what led to the Industrial Relations Act 1971, which is the first piece of legislation that we need to look at. And that is in the authorities bundle, and I will find the tab number.
69.
I'm grateful, at 69. No, that's wrong.
69.
It's 53.
I think I think Mr. Ford was referring to Lord Donovan's.
Yes, I'm
report.
referring to the Industrial Relations Act.
And that's at 53.
It's 53, and there we see the 1971 Act, and it's section 5. Is it page 1467? Section 5 of the Industrial Relations Act, rights of workers in respect of trade union membership and activities. Every worker shall, as between himself and his employer, have the following rights. That is to say, and then at C, where he is a member of a trade union, the right at any appropriate time to take part in the activities of the trade union, and the right to seek to accept appointment for election. And then at subsection 2, it shall accordingly be an unfair industrial practice for any employer or for any person acting on behalf of an employer to prevent or deter a worker from exercising any of the rights conferred by section 1. B, to dismiss, penalise or otherwise discriminate against a worker by reason of him exercising such a right. So subsection 2B includes both the prohibition on dismissal and the prohibition on penalising or discriminating against a worker for a number of things, including at an appropriate time taking part in the activities of a trade union. And appropriate time is defined in subsection 5 as being outside working hours or at a time within working hours with consent of the employer. And the way this section worked is that, we needn't go there, indeed I don't think we have it, but under section 106 of the Industrial Relations Act, employees had a right of complaint to an industrial tribunal if they were subjected to an unfair industrial practice. And that is what is comprised within subsection 2. If we could then go to page 1470, there we see that the Industrial Relations Act 71 also gave birth to, as it were, the right not to be unfairly dismissed. That's section 22. And if one goes on to page 1473, fair and unfair dismissal, one sees at page 1474, subparagraph 4, for the purpose of this act, the dismissal of an employee by an employer shall be regarded as having been unfair if the reason for it was that the employee had exercised or had indicated his intention to exercise any of the rights conferred by on the employee by section 5.1 of the Act. So that's what we've just been looking at. So that's how these provisions were first enacted in UK law. And we say they have a close resemblance to ILO Convention 98, but actually, although they're subject to evolution, the core of what are today sections 146 and 152 can be discerned in that first piece of legislation. What then happened was that if we go on, sorry, I should also show your lordships page 1478, which is a separate provision, section 26, relating to dismissal in connection with a strike or other industrial action. So under subsection 1, it applies when an employee is taking part in a strike or industrial action short of a strike. 2, if the reason or principal reason for the dismissal was that claimant took part in strike or other industrial action, the dismissal shall not be regarded as unfair unless it is shown, A, that one or more employees who also took part were not dismissed, or B, that one or more such employees were offered re-engagement. In other words, the dismissals are selective. And then, additionally, it says, and that the reason, or more than one, the principal reason for which the claimant was selected for redundancy or not offered re-engagement was his having taken action to which the next following section applies. And subsection 3 is this subsection applies to any action on the part of the claimant which consisted of exercising or indicating his intention to exercise any of the rights conferred on him by section 5.1. So at this point, the protection for dismissal for participating in industrial action required both that dismissal was selective and, in addition, that dismissal was for an impermissible reason in section 5.1, which includes participating in trade union activities at an appropriate time. Those were cumulative conditions.
So simply the fact of going on strike did not mean that a dismissal is unlawful.
No. And indeed, to an extent, that remains the case today, as we shall see. Yeah. So that's the 1971 Act. And we make the point that it would make no sense, the structure of that last section, if industrial action was included within the rubric of trade union activities at an appropriate time, because they're clearly two different criteria, both of which need to apply in order for Section 26 to apply. What then happened was that the Industrial Relations Act 1971, which coincided with a particularly turbulent period in British industrial relations, was repealed by the incoming minority Labour government in 1974.
Just before we leave 1971 Act, Section 26.
Yes, my lord.
I haven't looked at it for a long time, but 26.1 appears to apply to cases where, on the date of dismissal, the employee was taking part in a strike, not to cases where the decision to dismiss occurs after he's gone back to work.
Yes. So the Labour government comes in and it repeals the 1971 Act and then reenacts it effectively in two parts, in the Trade Union Labour Relations Act 1974 and the Employment Protection Act 1975. We see the thinking behind that in the extract from Hansard, which is at tab 70 of the bundle, page 1686. It's a short passage in the first column there. This is the Minister of State in the Department of Employment, Mr. Albert Booth. And the second paragraph in the first...
I'm so sorry, I was busy reading what Lord Privy Seal said. Could you give me the reference again?
It's page 1686.
Yes.
And it's the first column, the second paragraph there. The Minister says, the Employment Protection Bill is the second stage of the government's programme of industrial relations legislation. The first stage was the Trade Union Labour Relations Act, Trade Union Labour Relations Amendment Bill, repealing the controversial features of the 1971 Industrial Relations Act. This we intend to follow with an industrial democracy measure and will make a logical extension in this field. So we need to look at the two acts. The first is the Trade Union Labour Relations Act 1974. That is at tab 54, page 1484. Now, this is Schedule 1 to the 1974 Act. One sees at subsection 4 at the top of the page, for the purposes of this schedule, the dismissal of an employee by an employer shall be regarded as having been unfair if the reason for it was that the employee, and then at B, had taken or proposed to take part at any appropriate time in the activities of an independent trade union. So that is the equivalent of section 152 today. And if one goes to subparagraph 6, any reason by virtue of which a dismissal is to be regarded as unfair in consequence of subparagraph 4 or 5 above is hereinafter in this schedule referred to as an inadmissible reason. Curiously, appropriate time is not defined, and we'll see that that was remedied in the 75 Act. So that's, there we see the equivalent of what is today 152. If one then goes forward to page 1488, we're still in the schedule, paragraph 8. The provisions of this paragraph shall have effect in relation to an employee who claims he's been unfairly dismissed by his employer where on the date of dismissal he was taking part in a strike or other industrial action. 2, the reason shall not be regarded as unfair unless it is shown, and again then we have the selectivity criterion. Someone wasn't dismissed or someone was re-engaged, and again, and that the reason was an inadmissible reason. And you've seen already that inadmissible reason includes taking part in trade union activities. What the 74 Act did not have was a direct analogue of section 146. Detriment short of dismissal for taking part in trade union activities. That was introduced by the Employment Protection Act 1975, the following year, which is at page 1490. And if we go to page 1491, here we see at section 53, trade union membership and activities. Subject to the following provisions of this section, every employee shall have the right not to have action short of dismissal taken against him as an individual by his employer for the purposes of B, preventing or deterring him from taking part in the activities of an independent trade union at appropriate time or penalising him for doing so. And at subparagraph 2, appropriate time is defined in the usual way, and that is the direct ancestor of section 146. We see there fully formed, as it were, although there are some amendments which I'll come to. What we then have, and this is the additional pages which I handed up, which I'm grateful to my learned friends, is amendments to the 1974 Act in Schedule 16 to the Employment Protection Act. Paragraph 11 includes the definition of appropriate time, which was missing from the 1974 Act. Paragraph 13 includes a new, an amended provision in relation to dismissal in connection with industrial action. And that says that if you're taking part in industrial action, the tribunal shall not determine whether dismissal was fair or unfair unless it is shown that dismissal was selective. And that is the direct ancestor of section 238 of the 92 Act, as it now is, with amendments. Thereafter, things become a little more straightforward, I'm pleased to say, in that these provisions were consolidated into the Employment Protection Consolidation Act 1978. That is at tab 56. And we see at page 1498, section 23, the predecessor of section 146. So, action short of dismissal for participating in trade union activities at an appropriate time. At page 1502, we see section 58, the equivalent of section 152 today, dismissal relating to trade union membership. Dismission shall be regarded as being unfair if the principal reason was that the employed taken part in appropriate activities of an independent trade union at an appropriate time. And then at page 154, section 62, where an employee has participated in strike is dismissed when taking part in strike or industrial action, the tribunal shall not determine that the dismissal was fair or unfair unless it is shown that dismissal was selective. So we have broadly already the pattern we see today. Prohibition on action short of dismissal for participating in trade union activities. It's unfair dismissal to dismiss for taking part in trade union activities at an appropriate time. And there's this much more limited protection from selective dismissal in relation to taking part in industrial action.
Mr. Stillers, earlier you showed us that there were those cumulative conditions that had to be met. The word "and" you emphasised. Do we still find that in the 75?
No, that's now disappeared.
Right.
And that reflects a higher degree of protection for dismissal when participating in industrial action.
But it remained the case, did it, that the employer dismissing someone for going on strike as such was not an unlawful act? No. Because it's selective dismissal, which makes it unlawful. Is that right?
Well, it's not only that. It's that selective dismissal means that the tribunal can consider fairness.
Yes, I see.
If it's non-selective dismissal, the tribunal can't even consider it.
Well, absolutely. And my understanding, but please correct me if this is wrong, is that the view of industrial relations that was taken then and for many decades was that collective labour disputes were not thought to be appropriate to be adjudicated upon in a court or tribunal, whereas individual rights might be appropriate. Is that right?
My lord, I would respectfully adopt that, and indeed that would be entirely consistent with that form of provision. Yes. So
we haven't got, have we, the change made, I think, by the 1999 Act, which is now section 238A of the current Consolidation Act.
we'll come to that. We will come to
You're
that.
coming to that.
Yes, because it's true to say that protection against dismissal has been increased. And I'm going to take you all the way through, and I apologise, it's slightly laborious, but in my submission it is worthwhile just seeing how these flowed through. I'm going to take, if I may, your lordships, to one authority on these provisions, because it was these provisions that were subject of the decision of the EAT in Drew and St Edmundsbury Council, which is in it's tab 5, page 87 of the authorities bundle. And I need only show you what Mr. Justice Slynn said at paragraphs 12 and 13. In fact, may I invite the court to read those two paragraphs? So, in particular, we see in the latter part of paragraph 13, it said, it seems to us quite clear that there's intended by Parliament to be a distinction for the purposes of claim of unfair dismissal between what is an activity of an independent trade union and taking part in industrial action. It seems to us the distinction is borne out for the purposes of the legislation when one considers the terms of Section 23 and Section 28 of the Act. We do not find it necessary to set out those sections in detail. So, in my submission, it's clear and subject to Article 11, which will come to in due course, uncontroversial, that this legislation sought to deal separately with two different things: participating in trade union activities at an appropriate time on the one hand, and industrial action on the other. With that, we finally come to the up-to-date legislation, and that is the Trade Union Labour Relations Consolidation Act. I should take you then to tab 57. In fact, tab 60. Let's look at the up-to-date version. Page 1532. And that's the key section in this appeal. Detriment on grounds relating to union membership or activities. A worker has a right not to be subjected to any detriment as an individual by any act for the sole or main purpose of B, preventing or deterring him from taking part in the activities of an independent trade union at an appropriate time, or penalising him for doing so. Subsection 2, in subsection 1, an appropriate time means a time outside the worker's working hours or within his working hours at which, in accordance with arrangements agreed or with the consent of his employer, it's permissible for him to take part in the activities of a trade union, or, as the case may be, make use of trade union services. And the sort of central question in this case is, does that section, in the light of Article 11, require that it applies to a worker taking part in strike action or other industrial action? Now, if we turn on, please, to page 1536, there we see section 152, which we submit is the sort of sibling provision, it's the word we use, of section 146. It says, for the purposes of Part 10 of the Employment Rights Act, unfair dismissal, the dismissal of an employee shall be regarded as unfair if the reason for it, or if more than one, the principal reason, has taken part or proposed to take part in the activities of independent trade union at appropriate time. So, and appropriate time is defined in the same way. So these are parallel provisions. I should point out that section 146 applies to workers, section 152 only to employees. That's as a result of an amendment in the Employment Relations Act 2004. Section 152 can't, as the law stands, apply to workers more generally because the right to unfair dismissal is enjoyed only by employees, not Limb B workers. In our submission, it's important to see those provisions in the context of the wider scheme of the 92 Act. And in that regard, may I take the court to section 219, which is at page 1549. This is the classic immunity in tort. An act done by a person in contemplation or furtherance of a trade dispute is not actionable in tort on the ground only that it induces another person to break a contract or interferes or induces another person to interfere with its performance, or that it consists of threatening that a contract will be broken, and so on. That provides immunity in tort not just to unions but to individuals. So it applies to any person. And so that provides limited protection to workers in that it prevents them being sued in tort for inducing other workers to breach their contracts. It's much more commonly invoked by trade unions for obvious reasons. It's got a very long history. It was first enacted as Section 3 of the Trade Disputes Act 1906, and it's a long-standing pillar of domestic trade union legislation. It is now subject to very extensive conditions and qualifications, as the court will be aware, in terms of balloting, notification, and so on. And to that extent, particularly with the trade union legislation of the Conservative government in the 1980s, was sort of rather constrained by those. And as we'll see in the RMT case, the point in that case was, were the constraints to that so onerous that it led to a breach of Article 11. But that is a key pillar of the protection which is provided to individuals and unions in relation to industrial action, and is part of the landscape which, in my submission, needs to be taken into account. If we could then please go forward to page 1619. We're now into the up-to-date, this really derives answers, I hope, my Lord Justice Bean's question about what the current state of play is on protection for dismissal for industrial action. And there are three relevant provisions. So at 1619 we have 237. An employee has no right to complain of unfair dismissal if at the time of dismissal he was taking part in an unofficial strike or an unofficial industrial action. Over the page, unofficial industrial action is defined essentially as industrial action which is not authorised by a union where there is a union involved. So there's no protection at all from dismissal where one's within section 2371. If we then turn to page 1622, there we have section 238, dismissals in connection with other industrial action. Essentially, this applies where the industrial action is authorised, and so doesn't fall within section 237, but is also subject to protected industrial action exemptions in 238A, which we'll come to in a moment. But if it's neither unauthorised nor protected, we're in section 238. And that provides that in this section applies in relation to an employee who has a right to complain of unfair dismissal and claims to have been unfairly dismissed where at the time of dismissal, B, the complainant was taking part in a strike or other industrial action. 2, in such a case, an employment tribunal shall not determine whether dismissal was unfair or fair unless it is shown that the dismissal was selective. So in other words, where one's not in one of the other sections, we have replicated the historic provision, which is essentially the right to claim unfair dismissal is excluded where there are non-selective dismissals. However, importantly, if one looks at page 1623, subsection 2b, subsection 2 does not apply in relation to an employee who is regarded as unfairly dismissed by virtue of section 238A. So that overrides. We see that section at page 1625. This was first introduced by the Labour government in 1999, came into effect in 2000. For the purposes of this section, an employee takes protected industrial action if he commits an act which, or a series of acts which, he's induced to commit by an act which, by virtue of section 219, is not actionable in tort. In other words, if it falls within the definition in 219 and the union has complied with all of the balloting and union and notification requirements, we're within section 238A. Subsection 2, an employee who's dismissed shall be regarded for the purposes of part 10 as unfairly dismissed if the reason for the dismissal is that he took part in protected industrial action. And subsections 3, 4 and 5 applies to the dismissal. Now, subsections 3, 4 and 5 contain some very complex provisions as to what the protected period is. and I can summarise them for your lordships as following. The basic protected period is 12 weeks from the commencement of the protected industrial action. See section 238A 7B. However, that period may be extended by any period during which the employee is locked out by the employer. See section 238A 7C. It may also be extended if the dismissal takes place after the end of the protected period and the employee stopped taking protected action before the end of the protected period. See section 238A4. Finally, the period may be extended if the employer failed to take reasonable procedural steps to resolve the dispute. See section 238A5. Subject to those extensions, after the protected period, there is no automatic unfair dismissal. And the employer is free to dismiss employees who are taking industrial action with impunity, provided he doesn't do so selectively so as to fall foul of section 238.
But not for the first 12 weeks.
No, so in very, very broad terms, and employees participating in unofficial action have no right ever to complain of an unfair dismissal. Subject to section 238A, employees participating in official action can't claim unfair dismissal unless they're dismissed selectively, but there's no presumption of unfairness. If, but only if, industrial action is in furtherance of a trade dispute and the trade union has complied fully with the balloting and notice requirements, striking employees are deemed to be automatically unfairly dismissed if they are dismissed within 12 weeks of the commencement of the industrial action, subject to the extensions which I've just sought to summarise for your lordships. It really is as simple as that. But more seriously, there is no suggestion and certainly no finding of the Strasbourg court or domestic courts, and this is important in my submission, that these limited unfair dismissal protections to those participating in industrial action are contrary to Article 11 of the Convention. There's never been such a finding. And forgive me, in my submission, it's relevant in looking at the overall shape of this protective legislation to bear that in mind with respect. So, before moving on to Article 11, we make 3 submissions on the history of the legislation and its current terms. First, we submit that it is clear that the protection relating to participation in trade union activities at an appropriate time has always been considered by Parliament to be separate and distinct from the more limited protections applying to those participating in industrial action. That is the only sensible and rational explanation of the scheme of the legislation. Indeed, if taking part in trade union activities at an appropriate time included industrial action, Section 152 would be in direct contradiction of the provisions we've just been looking at, conflict with them directly, and yet they don't even refer to one another. Secondly, since their first appearance some 50 years ago in 1971, Sections 146 and 152 and their predecessors have broadly followed a parallel course. We submit that they are very much sibling provisions. Indeed, we would submit perhaps best described as fraternal twins. They're children of the same parent, the Industrial Relations Act 1971.
It's a very extended
I can carry on. They're children of the same parent, the Industrial Relations Act 1971, and have coexisted in parallel ever since, save for a 1-year interregnum in 1974 to to 1975, when the new minority Labour government reenacted the previous legislation in 2 stages. But we do submit, in the light of that, that Mr. Justice Choudhury's finding, with respect at paragraph 81A of his judgment, that these provisions developed separately is not correct. It would be more accurate to say that they've developed in close parallel and have been treated by Parliament as complementary provisions. Thirdly, our third submission on this is that whilst Parliament has consistently provided protection to those participating in trade union activities at an appropriate time, the protection afforded to those participating in industrial action has been much more limited. Historically, the employer has retained a right to dismiss striking workers with impunity, although the conditions in which the employer can do so have become increasingly restrictive. Despite many opportunities to do so, however, Parliament has chosen never to legislate to protect workers participating in industrial action from detriment. And in our submission, that's not surprising, because the law relating to industrial action is intensely controversial from a political and social perspective. It's seen major swings in different directions, from the industrial unrest of the 1970s to the restrictive legislation of the 1980s to the more expansive protection introduced in the 90s and 2000s. Industrial action brings the economic rights of employers into direct conflict with those of workers. By contrast, the protection of trade union activities at an appropriate time is relatively, or ought to be relatively, uncontroversial in our submission. It is a basic adjunct of the right to freedom of association, and the condition as to doing it at an appropriate time ensures that it will not be disruptive of the employer's business. There is thus no direct conflict of interest for the legislation to police, as it were, in contrast to the position with industrial action. And so we submit there's nothing surprising or irrational in the way that the legislation has developed.
Mr. Stillers, there's that point that you have made, and I understand that, but might it be said that the position is even more complicated in that even those who have tended to favour the rights of workers have not necessarily wanted those rights to be capable of adjudication in courts and tribunals. In other words, that certainly for a long time, the view was taken that collective labour disputes should be fought out, they should be supported, that there was a statutory immunity that you've shown us, but not necessarily individual rights, even the right not to be dismissed, didn't, as you've shown us, didn't always apply, and even today applies only in certain circumstances, subject to carefully prescribed conditions.
My Lord, I would respectfully agree, and indeed, in my submission, it is striking that this is the first time the issue about detriment for participating in industrial action has come before the courts. And in my submission, that reflects the sort of cultural, if I may call it that, my Lord, history of these provisions, which is that collective labour disputes, and in particular industrial action, tends to have been fought out or at the collective level, and not at the level of individual employment tribunal complaints and so on. And it doesn't appear that it's ever even been suggested until now that one needs the sort of protection that is being sought in this case.
So one could put the same point the other way, and I agree with you. It's astonishing that this point has never come up before, but that may be because employers don't suspend as a response to industrial action.
In my submission, that's also a point that is probably the case. But we did. It's interesting. I asked. I haven't got them here, but I asked my learned friend the Slarks just to look at the cases on sections 237 to 238A, just to see, because I've never actually been in one myself. And the interesting thing is there are such cases, and there are cases where individuals have been dismissed for participating in industrial action, and if necessary we can refer the court to those. So whilst I would respectfully accept that it's not been sort of commonplace for individual responses, it's certainly not unknown, and that's reflected in the case law on the dismissal.
You said there have been cases where people have been dismissed for it. Yes, that they're unusual enough, but they're they're catered for in great detail in 237, 238, 238A. At the other end of the scale, there are plenty of cases about what may be called the no work, no pay rule. But in between, there never seems to have been a case which has anyway made its way into the law reports where an employer has done what this employer did.
Yes, certainly not in this country, and that's why we're here today. But in my submission, that doesn't reflect a breach of Article 11. In my submission, if one looks at the scheme, there's protection against individual trade union activities. There's rather limited protection for dismissal. And between those, it's unsurprising that looking at the less draconian action that might be taken against those engaged in industrial action, Parliament has never thought it necessary or appropriate to provide any specific protection for that.
Now, you showed us in the decision of the Employment Tribunal the issue as it was distilled, paragraph 22, which comes to any detriment at all. So it was separated, as I think you showed us, from the particular facts of this case. Now, leave aside for the moment that dismissal might be thought to be a detriment on any sensible application of the word. Whilst there are no cases, and we're concerned with a suspension that was then overturned. I mean, would it be a detriment for an employer to say to those of its staff who are on strike, well, while you're on strike, you can't use the company gym. While you're on strike, although we've got, this is an example that was in the papers at the weekend of a company that has some holiday homes which it lets its employees work. Well, while you're on strike, you can't use those. So those I would have thought would be detriments. And another one that was particularly in my mind in the context of the debate between the parties about whether stopping pay is a detriment or not. What about a go-slow, where the workforce turns up for work, but the aim of the go-slow is to reduce production by 50%. And the employer says, well, I'm going to dock your pay by 50%. I'm not sure whether that one's come before courts, but that would seem to be a detriment.
No, and in due course, I propose to put a number of other examples to the court to illustrate the difficulty in making hard and fast rules in this area. But if I may say so, the case of discretionary benefits is a very good one. If, for example, an employer has a Christmas bonus for those staff working hard in the run-up to Christmas, a strike is undertaken by some of the workers deliberately to disrupt the business in the run-up to Christmas, causing huge damage to the employer. Is the employer still bound to give those who've gone on strike their Christmas bonus if it's a discretionary bonus? That's plainly a detriment. But it's not by no means self-evident that it's not an appropriate balance to strike for the employer to be able to do something like that. I will come to more examples in the appropriate time, but I very much have in mind the examples my Lord has posited. I should have just said one point which arises from what my Lord just said, which is that under section 146, we needn't go back, but subsection 5A says this section does not apply where the worker is an employee and the detriment in question amounts to dismissal. So that provides a sort of clear demarcation between section 146 and 152. Turning then to Article 11. Article 11 is at in the bundle at page 16. Within the Human Rights Act, it's tab 61, page 1566A, which is an additional page I hope has got into the court's bundle. I don't propose to take you there. It's very, very well known to the court. But the relevant limb is the right under Article 11.1 to form and join trade unions for the protection of workers' interests. It is, of course, a qualified right in that Article 11.2 permits restrictions on the right to freedom of association for the protection of the rights and freedoms of others. So it's a qualified right which, it's acknowledged, may require a balancing of workers' rights with those of whose rights may be affected by the exercise of the right. There is no reference at all to the right to strike in Article 11, although, as we'll see, it has been established in the case law of Strasbourg that the right to strike may be a feature of Article 11, albeit not a core feature. Now, the Strasbourg Court has over the years expanded and clarified the scope of Article 11 in various directions, and I propose to take the court to the authorities under three headings. First, I will go to the authorities which deal with the Strasbourg Court's general approach to Article 11 and how it should be analysed. Secondly, I will go to those cases which involve a direct interference by a public authority with Article 11 rights, most of them from Turkey. And thirdly, I'll consider those cases which are cited by the respondent as cases involving private employers, which in our submission, none of which in our submission are in reality about the right to strike at all. And I'll seek to develop that in a moment. But those are the three headings I would like to take at the court too. So first, the general approach to Article 11. And if we could begin with Wilson and the United Kingdom, which is tab 41, in the authorities bundle, page 1201. This was the case brought by the journalist at the Daily Mail. The employer de-recognised the union and offered financial incentives only to those who agreed to the de-recognition and signed new contracts. And the domestic law at the time did not prevent them from doing that. At page 1205, if we could look at that, please, we see that Section 23 of the 78 Act was the one at the time of the relevant events. Every employee shall have the right not to have action short of dismissal. This is paragraph 27 of the judgment. Every employee shall have the right not to have action short of dismissal taken against him as an individual by his employer for the purpose of preventing or deterring him from seeking to become a member of an independent trade union. This provision was reenacted as Section 146. And then at 28, after the Court of Appeal found for the applicants, they found that the incentivisation breached Section 146. Parliament enacted Section 13 of the Trade Union Reform and Employment Rights Act 1993 to amend Section 148 of the 92 Act by providing that where the employer's purpose was to further a change in his relationship with all or any class of his employees, then unless the employer's action was action that no reasonable employer could take, Section 146(1) would provide no remedy for the employee. So in other words, Parliament specifically legislated to reverse the decision of the Court of Appeal, which had gone in favour of the claimant. We then see at paragraph 41 of the judgment, the court articulates the distinction between positive and negative obligations. court observes at the outset that although the essential object of Article 11 is to protect the individual against arbitrary interference by public authorities with the exercise of the rights protected, the main addition, the positive obligation is to ensure the effective enjoyment of these rights. In the present case, the matters about which the applicants complain, principally the employee's derecognition of the union for collective bargaining purposes and offers of more favourable conditions to employees agreeing not to be represented by the unions, did not involve direct intervention by the state. The responsibility of the United Kingdom would, however, be engaged if these matters resulted from a failure on its part to secure the applicants under domestic law the rights set forth in Article 11. And then we see at paragraph 44, the court has consistently held that although collective bargaining may be one of the ways in which trade unions may be enabled to protect the members' interests, it's not indispensable for the effective enjoyment of trade union freedom. Compulsory collective bargaining would impose on employers an obligation to conduct negotiation with trade unions. The court has not yet been prepared to hold that freedom for trade union to make its voice heard extends to imposing on employer an obligation to recognise a trade union. Unions members must, however, be free in one way or another to seek to persuade the employer to listen to what it has to say on behalf of its members. And then this phase we will see a lot. In view of the sensitive character of the social and political issues involved in achieving a proper balance between the competing interests and the wide degree of divergence between domestic systems in this field, the contracting states enjoy a wide margin of appreciation as to how trade union freedom may be secured. And we submit, and we'll see that formulation in various points, that the key point is that where one is in the realm of, as it were, adjudicating or balancing the interests of employees on the one hand and employers on the other, this wide margin of appreciation applies. The court went on to find that paragraphs 47 and 48, that the UK law at the time was in breach of Article 11, principally because, we see this at para 48, by permitting employers to use financial incentives to induce employees to surrender important union rights, the respondent state failed in its positive obligation to secure the enjoyment of the rights under Article 11 of the Convention. So, in other words, by permitting employers effectively to bribe employees to give up collective bargaining, that was held to go to the heart of freedom of association. The next case in this section on the general approach of Strasbourg is Demir and Turkey, which is tab 44, page A1284. Now, this was a case in which a group of civil servants had formed a union and entered into a collective agreement with their public sector employer. And it was held that they had no authority to enter into collective agreements as Turkish law stood. The employer had no authority to enter into collective agreements. And then we see in the headnote in the second paragraph, the Court of Cassation quashed the second judgment of the District Court, holding that the international agreements in question were not directly applicable. It held that the absence of specific legislation, the trade union had not acquired legal personality and did not have the capacity to take or defend court proceedings. So this was a very serious breach. Some civil servants form a trade union, a public authority willingly enters into a collective agreement with them. Ultimately, the court decides that because there's no legislation permitting civil servants to form trade unions, the trade union does not exist as a matter of law and is effectively dissolved. It's difficult to imagine a more fundamental denial of the right to freedom of association in our submission. Now, the Grand Chamber commented generally on the development of Article 11 at paragraphs 143 to 146. And in particular, there's reference at 143 to Wilson. It said that the court considered that even if collective bargaining was not indispensable for the effective enjoyment of trade union freedom, it might be one of the ways in which trade unions could be enabled to protect their members' interests. And then at 144, as a result of the foregoing, the evolution of case law as to the substance of the right of association enshrined in Article 11 is marked by two guiding principles. Firstly, the court takes into consideration the totality of the measures taken by the state concerned in order to secure trade union freedom, subject to its margin of appreciation. Pausing there, that is why we submit that in considering the issue in this case, one must see Section 146 in the context of the panoply of protections that one has in domestic law. Secondly, the court does not accept restrictions that affect the essential elements of trade union freedom, without which the freedom would become devoid of substance. These two principles are not contradictory but are correlated. And then at 145, from the court's case law as it stands, the following essential elements of the right of association can be established: the right to form and join a trade union, the prohibition of closed shop agreements, and the right for trade union to seek to persuade the employer to hear what it has to say on behalf of its members. The list is not finite, on the contrary, it's subject to evolution. So, as at this point in Demir, the three essential elements are set out there. Notably, they do not include, and indeed they've never been held to include, the right to strike. Now, the next authority I would wish to take the court to is the Sindicatul Pastoral Selborne and Romania case, more pronounceably referred to as the Good Shepherd case, which is at tab 48, page 1377. Now, this was another decision of the Grand Chamber, and on the face of it, concerned with another pretty fundamental interference with Article 11, because the question in this case was whether Romanian Orthodox priests were permitted to form trade unions. And spoiler alert, that the finding was that they weren't, or at least that the legislation which prevented them from doing so did not fall outside Romania's margin of appreciation and was consistent with Article 11. Again, we see some helpful general explanations of the law in this area. And if I could ask the court to go first to paragraph 131 of the judgment at 1410. Para 131, it further reiterates Article 11 of the Convention presents trade union freedom as a special aspect of freedom of association. And although the essential object of that article is to protect the individual against arbitrary interference by public authorities with the exercise of rights it protects, and we emphasise this repeated reference to arbitrary interference by public authorities, because we're not in that here, there may in addition be positive obligations on the state to secure the effective enjoyment of such rights. The boundaries between the state's positive and negative obligations under Article 11 of the Convention do not lend themselves to precise definition. The applicable principles are nonetheless similar. Whether the case is analysed in terms of a positive duty on the state or in terms of interference by public authorities which need to be justified, the criteria to be applied do not differ in substance. In both contexts, regard must be had to the fair balance to be struck between the competing interests of the individual and of the community as a whole. Pausing there, if I may, that might be read as suggesting that the distinction between positive and negative obligations is no longer relevant or important. In my submission, that would be a misreading of that paragraph, as the other authorities will show. The point that's being made in my submission is one is always carrying out a balancing act, but the crucial distinction is that where one is looking at direct state interference, the balance is a very different one. The rights of workers being directly interfered with by the state, which is on the face of it a more egregious and direct interference. On the other hand, where one is in the the positive obligations context, where one is dealing with law which seeks to balance the interests on the one hand of workers and on the other hand of employers, there one is looking at two competing rights, and the nature of the balancing exercise is a different one. It's still a balancing exercise, but it's a different kind of balancing exercise, because there one is essentially seeking to find a balance between two different groups of individuals, each of whom have their own rights. At 133, the court says, in view of the sensitive character of the social and political issues involved in achieving a proper balance between the respective interests of labour and management, and given the high degree of divergence between the domestic systems in this field, the contracting states enjoy a wide margin of appreciation as to how trade union freedom and protection of the occupational interests of union members may be secured. So we submit there is that where one is dealing with measures which are balancing the interests of employers and employees, there the state quite clearly has a wide margin of appreciation. And that's apparent from para 133 of the Good Shepherd case. Notwithstanding that the ban on preforming unions was held to be justified, essentially because it was justified by maintaining the integrity of the Orthodox Church. And I won't take you to it, but we see that paragraph 162. The next authority I'd like to take the court to is the RMT case, which is at tab 47. Although it's earlier in the bundle, it would appear to have been decided before the Good Shepherd case, after the Good Shepherd case, because it refers to the decision in Good Shepherd. This was a case where the RMT complained about two aspects of the industrial relations legislation. It complained first that the balloting and notice requirements relating to strike ballots were so onerous as to amount to a breach of Article 11. That was the first limb of it. The second limb was that the ban on secondary action in the 92 Act constituted a breach of Article 11. Now, the Strasbourg court rejected the first complaint as inadmissible. And the reason it was held to be inadmissible was because in the event, the union had managed to comply subsequently with the balloting and notification requirements and held its strike. So quite evidently on the facts of the case, it wasn't prohibitive. And so that didn't even get to first base. It was ruled out of hand in limine. And for your reference, that's para 45. On the secondary application complaint, the Strasbourg court found it to be admissible but rejected it. And the key passages begin at paragraph 84. It's page 1369. The court will consider first the applicant's argument that the right to take strike action must be regarded as an essential element of trade union freedom under Article 11, so that to restrict it would be to impair the very essence of freedom of association. Of course, it's already decided a number of cases in which restrictions on industrial action were found to have been given to violations of Article 11. At the end of that paragraph, it says, more generally, what the above-mentioned cases illustrate is that strike action is clearly protected by Article 11. The court, therefore, does not discern any need in the present case to determine whether the taking of industrial action should now be accorded the status of an essential element of Article 11 guarantee. So it's accepted, as we do, that the right to strike is protected up to a point under Article 11, but the Strasbourg court declined the invitation to hold that it's an essential element of Article 11. Then at 86, In previous trade union cases, the court has stated that regard must be had to the fair balance to be struck between the competing interests of the individual and the community as a whole. Since achieving a proper balance between the interests of labour and management involves sensitive social and political issues, the contracting states must be afforded a margin of appreciation as to how trade union freedom and protection of the occupational interests of trade unions may be secured. Its most recent statement of the point, and referring to the high degree of divergence observed between domestic systems in the field, the Grand Chamber considered the margin should be a wide one. See Good Shepherd. The applicant relied heavily on the Demir judgment, in which the court considered the respondent state should be allowed only a limited margin. The court would point out, however, that the passage in question appears in the part of the judgment examining a very far-reaching interference with freedom of association, one that intruded into its inner core, namely the dissolution of a trade union, not to be understood as narrowing decisively the definition and definitively the domestic authority's margin of appreciation in relation to regulating through normal democratic processes the exercise of trade union freedom. The breadth of the margin will still depend on the factors that the court in its case law has identified as relevant, including the nature and extent of the restriction on the trade union at issue, the object pursued by the contested restriction, and the competing rights and interests of other individuals in society who are liable to suffer. So this is a restatement of the wide margin of appreciation in the context of strike action, and an explanation that Demir was a case of a narrow one because it was such a fundamental attack on trade union or on the right of freedom of association. Then at 87, consistent with that, if a legislative restriction strikes at the core of trade union activity, a lesser margin of appreciation is to be recognised to the national legislature and required to justify the proportionality of the resultant interference in the general interest with the exercise of the trade union freedom. Conversely, if it is not the core, but a secondary or accessory aspect of trade union activity that's affected, the margin is wider and the interference is, by its nature, more likely to be proportionate. At 88, as to the nature and extent of the interference suffered in the present case by the applicant in the exercise of trade union freedom, the court considers that it was not as invasive as the applicant would have it. What the facts of the case reveal is that the applicant led a strike, albeit on a limited scale and with limited results. It was its wish to escalate the strike through the threat or actual involvement of hundreds of its members. Jarvis, another separate company, not all involved in the trade dispute in question, that was frustrated. The court has noted the applicant's conviction that secretary action would have won the day. Inevitably, that can only be a matter of speculation. It cannot be said that the effect of the ban on secretary action struck at the very substance of the applicant's freedom of association. On this ground, the case is to be distinguished from those referred to in paragraph 84 about, which all concerned restrictions on primary or direct industrial action by public sector employees. Now, we will submit, those are the reference to the Turkish cases and other cases where there was direct interference by the state with the rights of public sector employees, and 84, those cases, which some of which we'll look at in a moment, are set out, Karakay and so on. But in our submission, it is significant that here the court characterises those cases as restrictions on primary or direct industrial action by public sector employees. Now, Mr. Justice Choudhury, in his judgment in the EAT, found that the reference to public sector employees was incidental. That's paragraph 52 of his judgment. But in our submission, the court would not have referred to that aspect of those cases if it did not have some significance. And as we will see shortly, those cases involved the state penalising directly, and often in high-handed ways, individuals for participating in industrial action. That was a significant feature of those cases, and none of those cases were concerned with balancing the interests of different private citizens. And then finally in RMT, if we could go to the second half of paragraph 89, Yet the subject matter in this case is certainly related to the social and economic strategy of the respondent state. In this regard, the court has usually allowed a wide margin of appreciation, since by virtue of their direct knowledge of the society and its needs, the national authorities, and in particular democratically elected parliaments, are in principle better placed than the international judge to appreciate what is in the public interest on social or economic grounds, and what are the legislative measures best suited for the conditions in their country in order to implement the chosen social, economic, or industrial policy. And we pray that in aid on the basis that the area we are in here is right in the centre of questions of social, political, and economic policy, which are controversial and have changed over time and are very much for the individual contracting state in our submission. Finally, then, on the general approach to Article 11, I would take the court to unite the Union against the United Kingdom, which is tab 49, page 1424. That case concerned the abolition of the Agricultural Wages Board, which in practice brought to an end collective bargaining in much of the agricultural sector simply because of the prevalence of very small employers, and therefore what was said to be the need for the Agricultural Wages Board to have effective collective bargaining at all. If we could turn to paragraph 53 of Unite the Union, please. There the court said, Article 11 of the Convention safeguards the trade union's freedom to protect occupational interests of its members, reference to Demir. In substance, it affords the members of a trade union the right to be heard with a view to protecting their interests and requires national law to enable trade unions in conditions not at variance with Article 11 to strive for the protection of their members. However, it does not guarantee any particular treatment by the state, see the Good Shepherd. According to the court's case law, the right of association in trade union context has a number of essential elements, and the court then sets out the same essential elements as cited in Demir, which does not include the right to strike. Over the page, paragraph 55, 8 lines down, again we see, in view of the sensitive character of the social and political issues involved in achieving a proper balance between the respective interests of labour and management, given the high degree of divergence between domestic systems in this field, the starting point is that contracting states enjoy a wide margin of appreciation as to how trade union freedom and protection of the occupational interests of union members are secured. And further down, the court has recently explained that the breadth of the margin depends on, among other things, the nature and extent of the restriction of the trade union right at issue, the object pursued by the contested restriction, the competing rights and interests of other individuals in society who are liable to suffer as a result of the unrestricted exercise of that right, and the degree of common ground between the member states. Then at 56, although the essential object of Article 11 is to protect the individual against arbitrary interference by public authorities, the exercise of the right to protect there may in addition be positive obligations. And then at 60, the court is of the view that the applicant's complaint should be viewed from the perspective of the respondent state's positive obligations, in particular whether the respondent state is obliged to have in place mandatory statutory forum for collective bargaining in the agricultural sector. The applicant argued the margin of appreciation was a limited one, relying on Demir. However, as the court explained in RMT, that was a case examining a very far-reaching interference with freedom of association. In the present case, by contrast, the question concerned the extent of the state's positive obligation in the area of collective bargaining. As the court's already noted, the social and political issues involved in achieving a proper balance between the interests of labour and management are of a sensitive nature. The starting point, therefore, is the United Kingdom enjoys a wide margin of appreciation in determining whether a fair balance has been struck between the protection of the public interest and the abolition of the AWB and the applicant's competing rights. So that case was unsuccessful, no breach of Article 11. If I may then seek to tie together the threads of the cases we've looked at, we make the following 3 submissions on the overall structure of the jurisprudence on Article 11. First, at its core, Article 11 is concerned with protecting the individual against arbitrary interference by public authorities. That is why, as we shall see, the Strasbourg Court has found against states who directly penalise workers for exercising their Article 11 rights. Secondly, however, there is an important difference between cases where the state is directly interfering with those rights as an employer and cases where one is concerned with the sensitive social and political balance between the interests of workers and employers, where, as it were, the state is the referee or arbiter rather than one of the players. In the latter case, the case law shows clearly that the margin of appreciation will be wider. Thirdly, we submit that the distinction between positive and negative obligations remains important, even if it can at times be difficult to define, and ultimately the court is always concerned with balancing competing interests and rights. There is a significant difference between balancing the right of workers against those of the state and balancing the right of workers against those of other private individuals, in this case employers, and those who use their services. So those are the first set of cases dealing with Article 11. I turn then secondly, and in view of the time, I'll have to take this slightly more swiftly, but I turn next to the cases which are, we say, involve the state directly interfering with the rights of employees. The first of those cases is Ezelin against France, which is tab 40, page 1167. Ezelin was a case not about industrial action, but about the right to protest of a French avocat practicing in Guadeloupe. Monsieur Ezelin was subject to a disciplinary sanction from the Court of Appeal for participating in a political protest. Although the case was decided under Article 11, it might more naturally have been considered under Article 10, in the light of which the court considered Article 11. So following a political demonstration against the judiciary, the applicant was subject to judicial investigation, discharged for lack of evidence. The principal public prosecutor then reported him to the chair of the bar. I'm sure we're all thinking there, but for the grace of God. Following a disciplinary hearing, the Bar Council found there was no basis for applying any disciplinary action. Notwithstanding that, the public prosecutor then appealed to the Court of Appeal, who imposed a reprimand and awarded costs against him. And we see that at page 1174. At para 19, the principal public prosecutor appealed to the Bastia Court of Appeal against this decision. At the hearing, he asked the court to impose the applicant a disciplinary penalty of a warning. The Court of Appeal reversed the Bar Council's decision. And we then see on the following page that towards the foot, he was subject to disciplinary penalty and awarded costs were awarded against him, and his appeal was dismissed. So you may say a rather heavy-handed approach to freedom of expression and professional freedom, given particular the views of the Bar Council and so on. But that's what the Court of Appeal did. The court found the interference was not proportionate, having regard to the special importance of freedom, peaceful assembly and freedom of expression. We see that at 1194, para 51. The court has examined the disciplinary sanction in question in light of the case as a whole in order to determine in particular whether it was proportionate to the legitimate aim pursued, having regard to the special importance of freedom of peaceful assembly and freedom of expression, which are closely linked in this instance, and it was held to be not proportionate. That decision, we submit, is entirely unsurprising in the result. The state, in the form of the Court of Appeal, penalised the applicant for participating in peaceful protest in circumstances where he had done absolutely nothing reprehensible, nor interfered with anybody else's rights. Such a right to peaceful protest is one of the hallmarks of a free and democratic society, and we submit this is precisely in the core of Article 11, the state, in a heavy-handed way, directly interfering with the rights of citizens. The next case, and I intend to refer only to 3 of these line of cases because there's an element of repetition, is Para K against Turkey, which is Para 42. This was a case where the applicant was a public employee, a member of the KESK union. We see at the top of page 1223, para 7, on 5th of September, the Istanbul provincial governor informed the competent authorities that the KESK, to defend the purchasing power of civil servants and raise awareness, would in particular slow down and make a break from work as well as demonstrate. The provincial governor asked the authorities concerned to take all the necessary and dissuasive legal measures against the staff who would take part in these demonstrations. So again, high-handed interference by public authorities directly in the rights of individuals. At para 11, the applicant received a warning, and we see the upshot at page 1227. The court examined the contested discipline, para 37. The court examined the contested disciplinary sanction in light of all the facts, determining particularly if it was proportionate to the legitimate purpose, given the prominent place of freedom of peaceful assembly. The court notes that the applicant was given a warning as disciplinary sanction because of his participation in a one-day strike organised by the KESK, of which he was a member. The sanction, minimum as it was, is intended to dissuade members of trade unions from legitimately taking part in such a strike day from taking action to defend the interests of their members. So we say again, high-handed direct action by the state against public employees. The final case, which I would like to take you to, is Dilek in Turkey, in this category, which is tab 43, page 1231. Another case of public employees in Turkey. The applicants were toll booth operators on the Bosphorus, also members of the KESK union. The KESK decided to take action on a national level. As part of the slowdown, 2 groups of applicants left their toll booths 3 hours. That's at page 1234. Turn to page 1235, para 11. On the 14th of December, the administration filed 2 cases for damages against the applicants for the regional court. The administration qualified the action complained of as a criminal act. So they were subject to criminal accusations by the state authorities for leaving their place of work. And we see the upshot at paragraph 12 On the 29th of December 1999, the court ordered each applicant to jointly and severally pay the sum of around just under €9,000 with interest on arrears. That being the loss of revenue from the toll booths. And the Court of Cassation upheld the judgment. The court found as follows, paragraph 66, page 1246. One should not lose sight of the fact that if the essential purpose of Article 11 is to protect the individual against the arbitrary interferences of public powers in the exercise of the rights it's enshrined. So that's what this is about, the arbitrary interference of public powers. It may also imply a positive obligation to ensure effective enjoyment of those rights. And then at 72, page 1248, the court examined the assumption of civil liability of the applications in light of the facts. The government has not explained, this is crucial, halfway down, the government has not explained whether the trade union had the possibility to defend the rights of civil servants by other peaceful means. While domestic provisions generally prohibit collective actions and activities by state officials without distinction, despite the significant changes that have taken place since 1997, given all the considerations, this was not necessary in a democratic society. So hefty fines imposed by public bodies directly on public servants who left their workplace briefly. We say this is all of a pattern, and I won't take you to them, but in our submission, Kaya against Turkey, which is tab 46.
Just before we leave that page.
Yes, my lord.
Is paragraph 68 of it?
Yes, so there's a recognition that the right to strike is an important aspect of trade union rights, but there are others. But in my submission, that does not negate the line of authorities which we've seen, which say it is not a core element. I wouldn't submit that involves finding that it's a core element important.
Yes. Well, I understand obviously the force of the fundamental point you're making by taking us through this line of authority, but just to test the point of principle, can I just ask you this? Suppose you had facts like Dilek, but the employer was a private sector employer. In your submission, could the state have legislation which A, made such going on strike a criminal act, and or could the state have legislation which, in the case of a private sector employer with people going on strike, rendered the employees and perhaps their trade union liable to civil suit? So in other words, there wasn't the kind of immunity from tort that we have in this country. We have now. We didn't always until the 1986 Act. Could the state go that far, even in the private sector context?
Well, in my submission, it's always going to be a case of balance, and it will always have to be looked at in the context of the overall range of protections involved. In my submission, it's highly relevant that one's dealing with private sector because there the rights of other citizens are in play. I would suggest that the imposition of criminal sanctions would be a considerably more serious interference than disciplinary or contractual sanctions. Moreover, I would accept that the imposition of very large civil liabilities, in this case, one imagines these workers were poorly paid and they were forced to pay thousands of euros. That may well be a relevant factor, but one can't make hard and fast rules, I'm afraid, in this area, because it's always a question of looking at the range of protections involved and whether it is held that those in the case of a private employer fall outside the wide margin of appreciation.
I'm sure you're right to distinguish criminal sanctions. That's obviously a state decision. But in this country, the what I usually call the golden formula immunities granted to trade unions and individuals are only in tort. Suppose you had in this country employers who, say, operating a toll booth, the employees go through all the balloting provisions required by Part 5, they get a majority in the ballot, they give notice, all that. Then they go on strike. Can the employer nevertheless sue the employees for breach of contract and claim as damages all the lost income? And perhaps they can in English law. And would you say, well, that's just too bad?
Well, what I would say about that is, yes, as a matter of English law, that's correct. And indeed, we cite authority in our skeleton where breach of contract claims were held to be bringable against individual workers. It seems to me that that type of detriment, particularly where it's disproportionate, may be closer to the line in terms of what Strasbourg would say was and wasn't compatible with Article 11. But in my submission, what one doesn't do is get from that hypothetical example to the proposition that the imposition of any detriment, including, say, a disciplinary sanction or a withdrawal of discretionary benefit or something of that sort, must necessarily be prohibited in order to comply with Article 11. And that, in my submission, is where we are with the EAT's decision.
Yes, but that's as it were, that's looking at the severity of the detriment, and Ezelin and Carasset, which you've just shown us, seem to me to suggest that Article 11 is at least engaged, even if the penalty is rather minor.
Yes. So my submission on that would be this, that the absence of protection for detriment, notwithstanding the example that my lord has posited, falls within the state's wide margin of appreciation. That's my primary submission. My secondary submission is that even if one can posit examples where imposing a particularly heavy detriment would and that being permissible in law, that would, on the face of it, involve a very serious interference with the rights of the individual. And this really is anticipating ground 2. It does not follow that there must be a blanket prohibition on any detriment for breaches, any detriment for participating in industrial action. And so, even if it may be right that there are, and this is not, we don't accept this, but even if this court were persuaded that there might be circumstances where it would be on the facts too grave an interference, our second ground of appeal says it's for Parliament to draw the line, and not for the court to say you can therefore never impose any detriment. Now, sorry to have to rush, but I want to attempt to sit down before lunch, if I can. Ognevenko and Russia is a slightly anomalous case. I won't take you to it, but just give you the references. It's tab 52, page 1450. There the applicant was a train driver with the state-owned Russian railways. He was dismissed for taking strike action. At the time, Russia had legislation which imposed a blanket ban on certain railway workers, including train drivers, ever striking. For your reference, para 59, the court pointed out that Article 11 doesn't exclude any occupational groups from its scope, although there is a reference to the armed forces, police, and administration of the state. But the key reasoning of the court was at paragraph 72 to 73, where it held that the fact that railway workers were not generally regarded as providing an essential service meant that a complete ban, and that was derived from the international instrument, a complete ban under all circumstances on them striking required justification with solid evidence, and it was found that Russia had not provided that justification for the blanket ban on railway drivers striking. And it was for that reason that in that case there was held to be a branch or a breach of Article 11. The key passage is paras 72 to 73, and the Russian state had simply failed to justify this very serious and absolute ban on striking for one occupational group. I turn then to the third category of Strasbourg cases, which are the private employer cases. And two are cited by my learned friends, Danilenkov and Tekgida. We deal with Danilenkov in some detail in our skeleton argument, but we submit that properly analysed, that case was not a case about the right to strike. Mr. Justice Choudhury read it as being so, but we say that's not correct. If we could go to tab 45, page 1304. Now, the key point is that page 1308, the DUR union took part in collective bargaining. Para 14, it had a 2-week strike. Following that, the Kaliningrad seaport were harassing DUR members. That's how events started. However, what then one sees is a catalogue of pretty vicious attacks on trade union membership. And just briefly to follow it through, at para 17, work is allocated away from the union members. At para 19, DUR officials are excluded from the lucrative work. At 21, they're kept understaffed. At 24, DUR representatives aren't allowed to be members of test committees. And then at 30 to 31, at page 1310, 33 dockers, formerly staff members, were transferred to their needed as contracts. The applicants pointed out that 27 of the transferred dockers were DUR members. The applicants' alleged transfer dockers were better qualified. On 11th of November 98, the managing director ordered that 47 dockers be made redundant. 35 of them were members of the DUR. What then happened is that the union took action, and one can see from paragraphs 47 to 49 that they were then caught in a catch-22, because although there was anti-union discrimination legislation, the courts held that that could only be enforced as a criminal sanction, and that you couldn't have a criminal finding against a company because it didn't have the right kind of legal personality. So complete catch-22. We see that at 47, legal entities such as the Seaport Company could not be held criminally liable, and that was upheld. 49, it was held that it lacked jurisdiction to establish whether there had been discrimination because such a fact could only be established in criminal proceedings. However, a legal entity could not be held criminally liable. So it's a complete catch-22. What then happens, if we go on to page 1318, is that a new collective agreement is entered into with a new subsidiary to divert work away from the DUR members. And at 79, as a result of the conflict, this is critical, DUR membership shrank from 290 in 1999 to only 24 in 2001. In February 2002, the remaining DUR members were made redundant and dismissed.
I have no idea what that is.
It seems to have stopped.
I hope so.
The critical point is, it's turning back to Danilenko, this was effectively the liquidation of a trade union. Extremely egregious campaign. And if one looks at the reasoning of the court, it's at pages 1330 to 1331.
Just before we leap to page 1330, Mr. Stillitz, can we have a look at paragraph 120 on page 1327?
Yeah.
They seem to me to be saying that really not interested in whether the Kaliningrad Port Authority is the state or not.
Yes.
What we're interested in is the responsibility of the state to secure the rights of the member.
Yes. So they treat it as a positive obligations case. In my submission, it's wholly unsurprising that they weren't particularly interested in that distinction in this case, because it was such a outrageous case, or an outrageous attack on a union which the law was manifestly inadequate to provide any protection because of the catch-22. So this was not, on any view, a borderline case. And we see that at page 1330. I won't take you through that in detail, but I can commend to the court paras 130 to 136. And I make 2 points about that. The first of all, whilst there is a summary of the campaign against the union, there is no mention whatsoever there of the right to strike. It's concerned with the campaign to liquidate the union, and it concludes at 136. In sum, the court considers the state failed to fulfil its positive obligations to adopt effective and clear judicial protection against discrimination. It follows that there's been a violation of Article 14 of the Convention, taken together with Article 11. So we make 3 submissions on Danilenkov. First of all, whilst there was, in the early history of the case, a strike, the findings of the court are based on the sustained harassment of the union to the point of extinction. And that's what this case is about. It's difficult to imagine a more serious attack on union membership. Secondly, a key feature was the catch-22. The law, whilst in principle providing protection, was wholly unenforceable because it could only be enforced by the criminal courts, who held repeatedly that the employer could not be capable of being criminally liable. Thirdly, in tellingly, the violation was found to be one of discrimination under Article 14 by virtue of the ineffective remedy, not a freestanding violation of Article 11. But we say, on any view, this is not a case about the right to strike, and it's certainly not authority for the proposition that the state is bound to prohibit any detrimental action by an employer against workers who take industrial action. Finally, Tek, Gida and Turkey, which is tab 50, That was a case about union membership, not about industrial action. It was about recognition of the steps taken by the employer to avoid it. If we go to para 51, the union members were dismissed and not reinstated, and therefore the union lost the chance of retaining its membership. And so again, this was, and I refer you just for your note, paragraphs 54 to 56. So in that case, the national law permitted an employer to dismiss union members without sufficient compensation, and that was held to amount to an unjustified interference. We submit to permit the dismissal of union members strikes at the very heart, just for being union members, strikes at the very heart of the right to freedom of association. So, having taken that rather laborious course through the authorities, we make 4 submissions in summary on Article 11. We submit that there is a significant difference between cases of negative and positive obligation, the key difference being that in positive obligation cases, the state is seeking to balance the competing interests of different groups of citizens, workers and employers, which brings with it a correspondingly wider margin of appreciation. Where the state is directly interfering with rights, a more stringent approach is taken. Secondly, the right to strike...
Can you just, for this, just go a little bit slower.
I apologise. Secondly,
Yes.
the right to strike is not, as things stand, one of the core elements of Article 11. Thirdly, the private sector cases cited by the respondent are not cases about strike action at all, but are in substance wholesale attacks on union membership, which strikes at the very core of Article 11. Fourthly and finally, it remains the case in our submission that there is no Strasbourg case involving a private sector employer where the mere imposition of a detriment, however minor, for participating in industrial action has been held to breach Article 11. I turn then finally, my lords, to the 2 grounds of appeal, which, with that extensive preamble, I hope I can take relatively swiftly. We submit that Article 11 cannot be said on the current jurisprudence to require that it must be unlawful for an employer ever to impose a detriment on workers before they've taken part in industrial action, and that in looking at that question, the balance to be struck between employers' economic rights and workers' rights is far from obvious. First, we make the point that industrial action will in general involve the direct interference with the contractual and economic rights of employers. And we submit that that is a point which is rather glossed over in the EAT's judgment. This is a very significant feature and really at the heart of the justification for the absence of more protection. Where the state provides protection to unions and workers who take industrial action, it is necessarily interfering with employers' rights, including, in principle, the right to peaceful enjoyment of property under Article 1 of the First Protocol. That's why the law surrounding industrial action is so inherently controversial. There's no easy option. One has to make difficult choices. The worker's gain is the employer's loss and vice versa. Secondly, and resulting from this first point, it has always been the case, and there is no authority or suggestion that this is inconsistent with Article 11, that in many circumstances, employers may lawfully be dismissed for participating in industrial action. The balance struck in that regard has ebbed and flowed with the political tides, but it remains entirely lawful and compatible with Article 11 for employers to dismiss workers for taking industrial action in certain circumstances. And given that dismissal is the most draconian remedy an employer can impose directly on an employee, it would be astonishing in our submission and wholly irrational if Article 11 nonetheless required a blanket prohibition on employers imposing lesser detriments than dismissal upon workers taking industrial action. Thirdly, and this comes to my Lord Chief Justice's earlier remarks, there are many examples one can think of where it is far from obvious, consistent with the right to freedom of association, that the employer should not be able to protect its rights by imposing a detriment. The most uncontroversial example is docking salary. Now, the respondent says, well, it's lawful at common law, and under Part 2 of the Employment Rights Act, there's an exception for industrial action. But we submit it's nonetheless a detriment to dock salary, albeit there's a consensus that there's nothing wrong with it, because it would be very unfair to the employer if they couldn't. One can test the point by saying, if an employer deducted salary for an after-work union meeting, would that be a detriment? Obviously it would. The fact that in these circumstances, even the ILO agrees that it's fair enough doesn't stop it being a detriment. But that's one example which clearly is justified, but not the only one. I've already put to the court the Christmas bonus example. Why should an employer be required to give a discretionary benefit based on goodwill to employers who have disrupted its business at the busiest time of the year? And it can be widened to discretionary benefits more widely, as my Lord said, gym membership or other discretionary bonuses or benefits in kind. It's by no means self-evident in our submission that employers should be compelled to confer those on employees who've, exercising their industrial muscle, disrupted its business. A fourth example, performance-related pay. Why should an employer be prohibited from taking into account attendance, where there's been non-attendance for strike action, or performance, where there's been a work to rule, as my Lord put it? Why should an employer be precluded from taking those into account in awarding performance-related pay? One can think of a fifth example. An employer has a discretion as to who to offer particular duties or shifts to. Is it, we say, it's by no means self-evident that the employer should be prohibited in allocating work from favouring workers who've attended and worked reliably, particularly for pivotal or mission-critical duties? A sixth example, when making decisions on promotion, we again say by no means self-evident that an employer should be prevented from looking at the reliability of employees in attending, and that's going to be impacted by their participation in industrial action. Finally, I mentioned disciplinary sanctions because one can imagine a case not very different from the present one, where, say, a care worker abandons their shift midway through as part of strike action and thereby leaves a vulnerable service user at risk. that might put the employer in breach of their duty of care or in breach of their regulatory duties. We submit that it is by no means self-evident that under those circumstances, the balance should not permit some form of disciplinary action to be taken. And so, in the end, what I'm submitting to your lordships, not is that there is an obvious answer necessarily to all of these points, but rather that depending on one's philosophy, political views, instincts, and so on, one might legitimately take different views in relation to these examples, and indeed Parliament may legitimately take different views in relation to these examples. And in circumstances where the Strasbourg Court has said repeatedly that the sensitive social and political issues arising from the competing interests of workers and employers permit a wide margin of appreciation, it's very difficult, and we say unwarranted, to find that Article 11 requires that these detriments can never lawfully be imposed on workers who've taken industrial action under any circumstances. But that is the effect of the EAT's decision.
Still, it's speaking for myself. I understand the force of the points you're making, particularly if they were being made under ground 2. But don't we, for the purpose of ground 1, don't we have to look at it from the other end of the telescope? That currently, as I understand it, correct me if I'm wrong, English law does not cater for any circumstances. So it's not that in all circumstances where there's detriment imposed, but it doesn't matter how bad or extreme or for how long a detriment is imposed, simply for the fact of taking part in industrial action. There is simply no legal course of action available. And is that compatible with Article 11?
Well, my lord, that brings me directly to the next submission I was going to make, which is that in answering that question, one has to look at the overall scheme of legislative protections, principally in the 92 Act, which are conferred on those participating in industrial action. And we pray and aid the following. First, the primary protection in respect of industrial action has long been the statutory immunity from tort contained in Section 219, which confers absolute immunity on workers, provided it's a trade dispute, and they don't have to comply with the balloting provisions. So that is one wide form of immunity. Secondly, sections 146 and 152 do confer very wide protection with the activities of trade unions which are not disruptive of the employer's business. And those are absolute protections. And so if one's looking at the overall scheme, those are very, very strong protections that apply in these circumstances. Thirdly, sections 237 to 238A of the 92 Act provide relatively extensive, although not unlimited, protection against dismissal for participating in industrial action. Again, that is an obvious desire by Parliament to strike a balance between employers' and workers' interests, but it doesn't follow that express protection against the lesser sanction of detriment is required or need be universal. Fourthly, there are a range of other protections relating to union membership and activity, including the blacklisting regulations, time off for officials for union activities, and so on. And we submit that the absence of a prohibition on detriment for participating in industrial action must be seen against that broad suite of protections for trade unions, their officials, and members in the UK. Fifthly, in the context of disciplinary action, there are a number of other constraints on employers. For example, they are bound to follow the ACAS Code of Conduct on Discipline. They are bound in how they conduct themselves by the implied term of trust and confidence. And those constraints are a fetter on employers acting in a capricious or high-handed manner if we're in the realm of disciplinary action. And so my submission is that, taken in the context of that landscape, it cannot be said that the current balance that Parliament has reached falls outside of the wide margin of appreciation conferred on states, given the sensitive social and political issues involved in balancing the interests of employers and employees. And that is why we say that any interference is justified. It's said by my learned friends, well, there isn't solid evidence of this justification. But in my submission, where one's dealing with such a classically political issue as this one wouldn't expect to see, for example, evidence as to the detriment to employers or the effect on employees of calibrating the industrial action legislation in a particular way. It just doesn't lend itself to that kind of analysis. The evidence here really is in the consistent approach that Parliament has taken and the choices that it has made. It chose to limit action in tort from immunity, but not others. It chose to have limited protections against dismissal, but not detriment. And in my submission, the fact that it's carefully crafted the rights in the way it has provides the justification one needs. And applying the Bank-Mellett approach of Lord Sumption, here the objective is to balance the rights of workers against those of the employer. The scheme of the 92 Act is obviously connected to that objective. Given that we're talking about action short of dismissal, a less intrusive measure would not achieve the same result. And in looking at whether a fair balance has been struck, the wide margin of appreciation in horizontal cases, the wide suite of protections, and the limited nature of protection against dismissal, we submit show that the current state of the law is consistent with Article 11.
Well, now, Mr. Stillitz, we have a clock in this court that's been stuck at 16 minutes to 8, I suspect, for rather a long time.
I'm very near the end of my submissions. All I need to deal with is ground 2. I'm extremely happy. I appreciate I've gone slightly longer than was intended. I can either finish quickly now.
I regret to say that other pressing matters mean that we have to rise now. I would imagine that given you've traversed all the statutory materials and shown us most of the authorities which Mr. Ford himself, I think, will wish to show us, that he won't be disadvantaged if you take 5 or 10 more minutes at 2 o'clock.
I will do the same. Thank you.
All right. Well, we shall see you again at 2 o'clock.